My name is Jamie McDonald. I'm an attorney with McDonald Law Offices. Our firm represents individuals in consumer bankruptcy cases throughout the state of Arizona. Today I'm going to discuss secured debts in Chapter 7. The most common types of secured debts are mortgages or deeds of trust, vehicle loans, purchase money security interests, and non-purchase money security interests. You have a couple of options with regard to a mortgage in a Chapter 7. If you believe that you can no longer afford the property or you simply want to get a fresh start, you do have the option of surrendering the house to the lender through the Chapter 7. If you surrender the house, the debt will be discharged. You'll no longer remain legally obligated for that loan. If the property that you are surrendering has a homeowners association, however, you have to look at something. Fees and assessments owed to a homeowners association at the time that the bankruptcy is filed are dischargeable in the bankruptcy. Fees and assessments that become due after the bankruptcy is filed and until the home is foreclosed upon are not discharged. That means you'll remain legally obligated for the fees and assessments from the date your case is filed until the foreclosure sale actually takes place. If you'd like to keep the home, you can do so as long as you have no non-exempt equity in the property and you're current with the payments on the first mortgage and any junior mortgages as well. In Arizona, we have a $150,000 homestead exemption, so as long as you have less than $150,000 equity in the property, you don't have a problem with the trustee in the Chapter 7 taking possession of and selling the property. If you are current with the payments, you'll have no problem with the lender. The lender cannot touch the property as long as you're current. If, however, you are not current or you fall behind during the Chapter 7 process, there is a possibility that that lender is going to file what is called a motion to lift stay in the bankruptcy, asking the court to lift the bankruptcy stay based on the default so that the lender can foreclose on the property. Another common type of secured debt would be a vehicle loan. You have three options regarding a vehicle loan in a Chapter 7. If you no longer want the vehicle, you want to get a fresh start, you think you cannot afford it, you can surrender that vehicle to the lender through the Chapter 7, the debt will be discharged. You will no longer remain legally obligated for that vehicle loan. If you want to keep the vehicle, you can do so as long as you don't have any non-exempt equity in the vehicle and you enter into either a reaffirmation agreement or a redemption agreement. A reaffirmation agreement is an agreement that you sign with the lender after your case is filed where you're waiving your right to have the debt discharged. You'll remain legally obligated for that debt. A redemption agreement is where you enter into an agreement with the lender based to determine what the value of the vehicle is, and then you pay a lump sum to that lender to cover the value of the vehicle. You usually basically obtain the financing through another outside party to pay off the lender the vehicle's value. You pay off the lender, they release their lien. Now you just have a new debt through another creditor, usually quite a bit less than what you owed originally. As far as the non-exempt equity in a vehicle, if this is a single case, a single debtor can exempt $5,000 equity in a vehicle. If it's a joint case, you can exempt $10,000 equity in one vehicle or $5,000 equity in each of two different vehicles. The third type of secured debt we generally deal with would be a purchase money security interest. A purchase money security interest would come into play when, let's say, you financed some furniture, appliances, jewelry, and in financing that furniture, appliances, or jewelry, you granted that lender a security interest. It's usually buried in the fine print. You really have to look for it to find it, but it is usually in there. If you've granted a purchase money security interest in those items, that lender then has the right to repossess that property from you if you default on the agreement. You have basically three options regarding the purchase money security interest. If you would like the fresh start and simply surrender the collateral, you can do so. If you would like to keep the property, you can enter into either a reaffirmation or a redemption agreement. If, however, the lender does not enforce their security agreement, the debt's going to be discharged and you can retain the collateral. A fourth type of security interest would be a non-purchase money security interest. These security interests usually come into being when you go into a lender to take out a loan, and the lender requires you to list items that you already own as collateral for that loan. This is called a non-purchase money security interest. The options regarding non-purchase money security interest vary. If the items you pledged as collateral for that loan are exempt under the state statutes, you can simply file a motion to avoid the lien on that property and retain the collateral, and the debt is discharged. If the collateral is not exempt under the state statutes, you can either enter into a reaffirmation agreement or a redemption agreement.